David, kick it off? All right, David's going to kick us off. Thanks.
Hi, everyone. Welcome back from lunch. I'm David Peloquin. I'm a partner just across the Charles River at Ropes and Gray in the Prudential Tower. And I have had the privilege of working with Rebecca Lee since before Vivli was formed. Back in 2013, I was doing work for the Multi-Regional Clinical Trials Center, founded by Barbara Beerer, who's here somewhere. And they were doing a whole session on data sharing and what data sharing of clinical trials could look like and what were the issues. And we were talking about things like EMA Policy 70 and sharing data under that regime. ClinTrials.gov was still kind of new, and we were trying to think about how that might encourage data sharing, and there were the new journal policies. And it was a privilege to work with Rebecca and her team on a pro bono basis to help them form Vivli as a nonprofit organization here in the Commonwealth of Massachusetts back in 2017 and provide advice to the organization since then. And Rebecca kindly asked me to come today to talk about a new set of regulations that I've been spending a lot of time working with a variety of companies on, health systems, universities, pharmaceutical manufacturers, and other organizations involved in sharing data across borders. And I'm pleased to give you kind of an overview today of what these regulations are and how in particular they affect clinical trials and data sharing of clinical research data. One thing I always say at the top of these presentations is that this is not legal advice. It's intended to be informational. And I do represent a number of the institutions who are represented here in the room today, but even if I represent your company, what I'm saying today is not being provided as attorney-client communication to you, but rather general information. The last thing I'll say is that I love it when people ask questions. So if you have a question or an experience you want to share, please shout it out. We're a relatively small group today, and I think everybody would love to learn from one another. So the topic is navigating data sharing compliance under the Department of Justice final rule on transfers of sensitive personal data to countries of concern. And we're going to talk in particular about some operational impacts, and Julie is going to talk a little bit about how Vivli has been approaching this rule. But to set the stage here, what we're talking about really goes back to the end of the first Trump administration and the Biden administration, in which there are lots of concerns about the sharing of technology, the sharing of intellectual property, and increasingly the sharing of data and biological specimens with countries of concern, first and foremost the People's Republic of China. And we have seen several trends, both in Congress and in executive agencies and at the state level in the United States, that are attempting to redefine the relationship between the United States and China and these other countries of concern. Some of you may have heard of the Biosecure Act, which is something that has still been proposed in this Congress. That's coming from the same trend. We had a law called the Protecting Americans' Data from Foreign Adversaries Act that took effect about a year ago that was also concerned with sharing of data with the People's Republic of China and these other countries of concern. And what I'm going to talk about today is in particular an executive order that President Biden put out and the subsequent rulemaking that has now resulted in a final rule that places really severe limitations on the ability to share data of U.S. persons and biological specimens of U.S. persons with China and other countries of concern. But I think it's important to remember, as I've already alluded to, this is a bipartisan issue. What I'm talking about today, when we hear the term executive order now, we're often thinking of all the executive orders that have come out in the Trump administration since January of this year. But what we're talking about today actually came out in February of 2024 when President Biden issued this executive order entitled Preventing Access to Americans' Bulk Sensitive Personal Data and United States Government-Related Data by Countries of Concern. And it's important to remember this executive order is still out there, and the Trump administration continues to cite to it. And this executive order did a lot of things, but the one we're going to spend most of our time on today is it directed the U.S. Department of Justice to issue regulations that would restrict or prohibit transactions that involve bulk sensitive personal data, we'll talk about what that means, or United States government-related data, and countries of concern or covered persons. And the countries of concern, as I already alluded to, include the People's Republic of China, including expressly Hong Kong and Macau. They're all in scope. Russia, Iran, North Korea, Cuba, and Venezuela. And the law that this was promulgated under, or issued under, is IEPA, the Emergency Economic Powers Act, which is the same statute that the Trump tariffs have issued under. So there's a lot of use of that statute by both administrations, really. The final rule was published on January 8th, so less than a year ago. President Biden was still president then, hard to believe, in this year, and took effect on April 8th of this year. And a big question was whether the Trump administration was going to move forward with this rule, because obviously they have not moved forward with a lot of things that the Biden administration put into effect. And so I think people were slowly during the winter starting to think about, oh, this rule was finalized. Is the Trump administration going to do something to stop it? And we got our answer on April 8th. The rule took effect, and 3 days later, the Trump Department of Justice issued extensive guidance on how they intended to enforce the rule. They gave people a little grace period until July 8th, so a few months ago, to come into compliance. And now the rule is fully effective, including all of its record keeping and due diligence requirements that took effect earlier this month. So the Trump administration is moving forward with this Biden-era rule. I think the other thing to know that I don't have on the slides, but the way this rule came about, we had this executive order in February 2024, and the very same day, the Department of Justice did put out an advance notice of proposed rulemaking about how they intended to shape this regulation. And there was extensive notice and comment on that. And then there was a notice of proposed rulemaking last October. I think the proposed rule came out exactly a year ago. And another round of comment, and then the final rule on January 8th. So that was an example of traditional notice and comment rulemaking, albeit on an accelerated time frame. But the original proposal the Biden administration put out had no exemptions for clinical research, no exemptions for approval of life sciences products, and that was something they sought comment on. And a lot of my clients, through trade organizations or directly, were commenting on the proposed rule, which ended up shaping the final rule. And so I think that's an important thing just to keep in mind, that there was this, traditional notice and comment process with this rulemaking. And so what the rule is attempting to do is to essentially categorize data transactions into two buckets, what they call covered data transactions under the rule. And the covered data transactions include both prohibited transactions, so some transactions are prohibited, full stop, can't go forward, and others are prohibited unless they comply with certain types of record keeping and security requirements and due diligence requirements, and those are called restricted transactions under the rule. And in order to implicate the rule, the transaction has to involve a U.S. person on one side, like a U.S. company, U.S. nonprofit organization, and a country of concern or covered person on the other hand. And there's also certain restrictions in the rule on if you're a U.S. company and you're dealing with a foreign person who's not one of these countries of concern, like a French person, for example, or a Canadian person, and you're providing them data or biospecimens, you have to restrict their ability through contract to make an onward transfer of those data or biospecimens to a country of concern or covered person. In order for the transaction to implicate the rule, it also has to involve sensitive personal data of U.S. persons in excess of certain predefined bulk thresholds. And we'll talk about what those thresholds are in a moment. And this is a criminal regulation. There's criminal penalties with it in addition to civil penalties. So it's not a strict liability regime. There is an element of scienter, as we say in the law, or knowing. You have to knowingly engage in one of these transactions. And whether you are knowingly engaging in it is judged by all the facts and circumstances surrounding the transaction. And so, as I mentioned a moment ago, we have prohibited transactions, and the two types of prohibited transactions are what they call data brokerage. We'll talk about what that is in a moment. And then covered data transactions that involve bulk omic data or human biospecimens from which such data can be derived. And the second piece about bulk omic data has had a huge impact on the life sciences community and a lot of the clients that I work with. And then the restricted transactions include vendor agreements, employment agreements, and investment agreements, and we'll talk about what those are. But one thing that I will say here and then repeat again later is that if you're dealing with omic data or biospecimens, then you will never be restricted. It will always be a prohibited transaction under the rule. And so that's something to keep in mind, that the rule really privileges or protects those types of data, omic data, and the biospecimens from which they can be derived, much more than any other type of data. And the rationale for that is that this regulation, it's not about privacy. It's not about my rights as an individual to the privacy of my genetic information. It's all about national security. And the idea when you read the rule is that there's a concern that the omic data and the biospecimens from which it can be derived could be used by the countries of concern to fashion a bioweapon that is more precise against the US population. That's the rationale here. So if it seems like this is very draconian on sharing, that's the intent in many ways. When we talk about sharing bulk data, bulk specimens, it's not just the governments of these countries that we're concerned about. We're also concerned about people called covered persons. There's a lot of text on this slide. It's a good reference for you later. I'm not going to go through it in a ton of detail, but I think the key things to look for is a covered person. If we're talking about an entity, it's going to be anybody who is organized under the laws of a country of concern. So if you're a corporation organized under the laws of Venezuela or chartered in Venezuela, you're going to be a covered person. Or if you're an organization that is 50% or more owned directly or indirectly by such an organization. So let's say you're organized under the laws of France, but you're 60% owned by a Chinese entity. Well, that French entity then becomes a covered person under the rule. If you're an individual, you're going to be a covered person if you are an employer contractor of the government of one of these countries of concern or one of these other covered person entities, or if you are primarily resident in the territorial jurisdiction of a country of concern. There's another way you can become a covered person, and this is the only way a U.S. person could become a covered person. The Attorney General of the United States can designate people as covered persons if she determines that they're under the control of a country of concern or likely to act for a country of concern. She hasn't done that yet. She will publish a list of those types of companies and entities, but that's something else to watch for. And that would be the way, for example, the way covered person is defined. If you're a U.S. corporation, you're not going to be a covered person because you're not a foreign person. But the Attorney General could, for example, decide to designate certain U.S. companies, like a U.S. subsidiary of a Chinese entity, as a covered person. So that's something we're watching for. When we're talking about the type of data at issue and the type of companies that are regulated, we're concerned with U.S. persons. And a U.S. person, if we're thinking about individuals, are going to be people who are U.S. citizens, nationals, or lawful permanent residents, or people who are refugees or have been granted asylum in the United States. And if we're talking about entities, it would be companies that are organized solely under the laws of the U.S. And then this last bullet is important for a lot of universities and academic medical centers that have visiting researchers. You're also a U.S. person if you're located physically in the U.S., regardless of your citizenship. And so I think this was added to allow foreign people who are in the US to continue to work in labs where they might receive certain data. But the challenge is once they leave the US to go back to their country of origin, they're no longer going to be a US person under the rule. So I mentioned that the rule is all about bulk US sensitive personal data. What does that mean? Well, there's 6 different categories of bulk sensitive personal data. And we're talking about data of US persons here. So if you are doing a transaction, doing data sharing with data of Europeans or people from Mexico or Canada, the rule doesn't care about that. This is very America first. We're worried about data of Americans and only Americans under this rule. And so the categories of bulk sensitive personal data include things like covered personal identifiers. That's things like your name, social security number, driver's license number. And in order to be implicated by the rule, you need 100,000 or more US persons' data involved in the transaction, which that's a pretty high bar. But if we're thinking about what's most relevant for people in this room, we have personal health data, for which the threshold is 10,000 or more US persons, biometric identifiers, for which it's 1,000 or more US persons, and then human omic data, or the biospecimens from which they are derived, for which the threshold is 1,000 US persons if we're talking about omic data that's not genomic data. And if we're talking about genomic data or any type of biospecimen from which it can be derived, the bulk threshold is 100 persons. And it's that 100-person limit that has become why this rule is having such a big effect on so many life sciences companies and other people engaged in research that involves genomic data. I bolded here a key point at the bottom that because this rule is not about privacy, there's no exception for anonymized or de-identified data. And the rationale, again, is that the people who drafted the rule said it doesn't really matter if the country of concern can identify that this is David's genomic sequence or Barbara's or Julie's. They're concerned about the characteristics of the population of the US. And so the fact that they have a large volume of genomic data about US persons could be used against the US. That's the policy rationale for not excluding de-identified or anonymized data. And the bulk thresholds, how do you calculate if we have 100,000 persons data or 100 persons data? You're looking at all the transactions between the same US person and the same covered person. So between the same US company, let's say, and the same Chinese company, you add up all the transactions over a 12-month period and say how much data, how many biospecimens of US persons have we shared over that rolling 12-month period. And Julie's going to talk a little bit about that later on. Yes.
Can you define biometric?
Yeah.
Besides fingerprint and retinal scan, what else?
Yeah, so biometric is fingerprints, retinal scans, voice prints, things that are, facial image. Thank you, Barbara. Like it's largely mapped to what you would find in like the state laws and biometrics, like the Illinois law. That's a good question, and that has not come up before, but I suspect we could find an answer if we dug into the rule. That's a good point, good question. But that fetal ultrasound would definitely be health data under the rule. It's just what threshold you're at. So the prohibited transactions are data brokerage, which is the one that's probably most relevant if you're involved in any type of licensing agreement where you might be sharing data with another party under a license. And data brokerage is kind of a misnomer because when this rule came out, a lot of my clients are like, oh, we're not data brokers. We don't have to worry about this rule. But then when you dig into the definition of what a data broker is, it's anybody who's selling data, licensing data, or otherwise providing access to data as part of a commercial transaction. And you're providing data, it can be data you collected yourself and you're licensing it to a third party. That could be data brokerage under this rule. Also, if you're engaged in data brokerage, with bulk data in excess of the bulk threshold, with somebody in China, a covered person, it's going to be prohibited unless you can fit within one of the exemptions we'll talk about. There's also these onward transfer limitations on data brokerage. If you're doing a licensing agreement with a French entity or a Canadian entity that involves bulk US sensitive personal data, by contract, you have to limit that foreign person, that Canadian or French entity, from making an onward transfer of the data to a country of concern or covered person. And the reason for that is that the DOJ can't as easily regulate these foreign parties, so they're trying to make US entities regulate the foreign parties by contract.
Another quick question. Given the temporal sequence you said about total number in a 12-month period, if I sent 200,000 pieces of data on April 7th, do I have to go back and get it?
No, you don't go back before April 8th. That's one of the few clarifying things that the DOJ said in their guidance, their FAQs they put out on the rule. So we're counting since April 8th, 2025. That's a very good question. And then as I mentioned earlier, there's also prohibited transactions that involve humanomic data and human biospecimens. And so if you're engaged in one of these data brokerage transactions above the bulk threshold, it's going to be prohibited regardless. But if you're engaged in a vendor agreement or investment agreement or employment agreement, that would be prohibited if it involves omic data or biospecimens from which the omic data can be derived. There's a narrow exemption for diagnosis and treatment, like if you're sending a sample to a lab in China that's going to do a specialized test that's only available from that lab, and it's to treat a patient here in the US, you may fall into that exemption, but that's a pretty rare exemption. As I mentioned, there's also these restricted transactions that are investment agreements, vendor agreements, and employment agreements. These types of transactions, like if you hire a lab as your vendor in China, that may be able to move forward as a restricted transaction if you put in place the security, due diligence, and record-keeping requirements that are spelled out in the final rule. this seems like, oh, well, this might be helpful. It'll allow a lot of things to move forward, like vendor arrangements we might have. The challenge is that there's quite a long list of security requirements that one has to put in place with those vendors that are engaged in the restricted transaction. And what a lot of our clients have found is that the arrangements become almost unworkable when you put in place all these restrictions, because the vendor often can't actually use the data, because the whole goal is to like limit their access to the data. But if the service they're performing requires access to the data, then it's difficult for them actually to render that service. So in a way, a lot of clients have been not availing themselves of this flexibility to have these types of vendor arrangements if they put in place all these restrictions. So there are some exemptions in the rule that may apply to certain activities of entities that are engaged in research. I'm going to talk about a few of them today. There's 11 exemptions in the rule. That is, the exemptions are for a transaction that would otherwise be prohibited or restricted, but the rule says we're going to exempt the activity from most parts of the rule. And so when we look at what those transactions or those exemptions are, one is for official business of the U.S. government. And this is exempting grantees and contractors of federal departments and agencies with respect to activities that fall within the scope of the grant or contract. So if you have a federal grant from the Department of Defense, let's say, to do certain research, and the grant envisages you hiring a lab in China to help with the research, that could move forward because it's part of a federal grant or contract. And you might say, why is there this exemption? This seems to undermine the policy behind the rule. Well, it goes back to that executive order from President Biden, because in that executive order, he said, I want to not have duplicative regulation. So the DOJ will do its regulations, and that's mainly going to apply to the private sector, and the other funding agencies of research or other activities should issue their own guidance or regulations that will apply to the activities that they're funding. And we're seeing that the Trump administration has not forgotten about that authority, because tomorrow a new NIH policy takes effect that prohibits the sharing of all biospecimens of U.S. persons that's collected, obtained, stored, or used or distributed using ongoing or new NIH funds with institutions or parties located in countries of concern. And this is more stringent than the DOJ rule because there's no bulk threshold, like even one biospecimen would be prohibited under this. And there's only 3 very narrow exemptions for things that are authorized by federal law, like a treaty that we might have with the WHO. If the transfer is needed for some type of rare and compelling circumstance where the technology is not available in the US and the individual whose sample is being sent has consented to it. And also transactions that are made at the request of the data subject, the person from whom the specimen was collected, and with their consent. So this is something taking effect tomorrow, and I think we're going to see more policies like this as the current administration looks back to the Biden executive order to say this is the authority by which we're going to release this new policy. There's also an exemption for what are called corporate group transactions. I won't spend a lot of time on that. That's like if you're a multinational company, you can share data for HR purposes, tax purposes, things like that. But explicitly, this exemption says it does not apply to R&D activities. So it's not very helpful for research purposes. There's an exemption for what's called regulatory approval. I've spent a lot of time working with clients on this exemption. And this applies when you have to share data where it's necessary, that's the key word, necessary, to share data with a country of concern or covered person in order to obtain or maintain regulatory authorization or approval to research or market a drug, device, or biological product. And here, the key thing to think about is it necessary to share these data in order to obtain or maintain the approval? Is that required by law is really what the rule is thinking about. So for example, if you're a US pharmaceutical manufacturer and you want to market your drug in China and you have to submit data to the NMPA, that would be allowed because that is required. It's necessary for you to obtain approval to market the drug in China. If you want to use a vendor in China to help you prepare the submission to NMPA, that will only be allowed if Chinese law requires you to use an in-country vendor, because the rule says it's not necessary for you to use a vendor in China unless law in China requires that. So that's really important to think really carefully about what data you're sharing and what's required by law and what might be done as a matter of convenience. Another exemption, and the last one I'll mention, is there's an exemption for clinical investigations that are regulated by the US FDA. So like a clinical trial that's being done under an IND or an IDE, but it has to be that the transaction is ordinarily incident to and part of the clinical investigation. And the commentary on the rule says it can't just be in furtherance of the investigation. It can't just be helpful for the investigation. It has to be part of the clinical investigation. And that's not incredibly clear. There's not a lot of guidance on what that means. So clients have spent a lot of time thinking about at what point is the activity part of the IND regulated study. But I think then there's a separate exemption for post-marketing surveillance for marketed products, allowing the sharing of data that's required to be submitted to US FDA to maintain approval of a product here in the United States. One thing to note is that FDA has also been thinking about this rule. And in June of this year, a very interesting press release came out from the FDA criticizing the Biden administration for including the exemption for clinical investigations in the rule, suggesting that it was overbroad. And the focus of the FDA commissioner in his press release was really on cell and gene therapy trials, and he was concerned that cells of Americans were being sent to China, manufactured and sent back to the US for infusion into patients. And he said that the FDA would be scrutinizing those studies very carefully going forward, and in his companion podcast, he also suggested that there was a need for greater transparency in consent forms for trials in the US about when materials are being shared with China. We haven't had further guidance from FDA on this, and I haven't heard from any clients that they've had trials scrutinized by FDA under this, but this is something definitely to watch for. So I think the key thing to know is we have this DOJ regulation, but then we have other parts of the federal government that are going to be relying on the same executive order from President Biden to put out additional rulemaking or additional guidance. And now the Trump administration is very well aware of this existing executive order from the last administration, and they're using it to advance their own policies. And so that's something I think that we will all be watching for in the coming months. And this is kind of a flow diagram you can take home with you that talks about how you would evaluate whether a transaction is prohibited or restricted. I'm not going to go through it in detail, but it might be helpful for you if you're trying to figure out if a certain transaction your company is considering might implicate the rule, and if so, what the consequences of that would be. Yes, we'll be sharing the slides. And with that, I think I'm going to turn it over to Julie, but I will just say this is one of the most complicated regulations I've dealt with because it's all new. We've never seen anything like this in the United States before. And I think when you're dealing with it in interpreting, it's really helpful to go back to the policy. And remember, this is not about privacy, it's about national security. And if we were thinking, putting our national security thinking hat on, what would we try to do? That's really how I find it helpful in talking with clients and thinking about how to interpret this to keep those kind of bedrock principles in mind. Julie?
Well, thank you very much, David, for kind of outlining this very, very complicated DOJ ruling. And we could not have gotten to where we are without the help and just vital support of David and the entire Ropes and Gray team to kind of talk through how are we going to implement this ruling. Remember, this came out, the final ruling came out in January. We had until April. I mean, we'd been following it before then, but that's a pretty short window to then talk to all of our members, make sure that all of our members understood the policy, and we came up with a way of dealing with it and a way of implementing it. So I'm going to talk to you about what have we actually done, what are the steps we have taken to implement this ruling as it came through. So the first thing we did when the ruling came out is we've had a series of conversations with our members. And just as a reminder, so we have over 55 members at Vivli, so that's a lot of conversations to get everyone to understand an incredibly complicated piece of DOJ ruling. So those are all the members. The first thing we did, and the first thing we all agreed, because if you remember, Steve asked the question about what happens about previous to April 8th on 2025. So anything that took us over those bulk thresholds that David was talking about all those requests that were an analysis from countries of concern that were over, they were removed from the platform. So we had to basically, I think of it as we started fresh on April 8th. So that was kind of our go forward date. So that was the first thing we did. And then we started looking at how do we manage the requests coming forward. And most of these, when we're talking about it, it really is looking at requests from China. That's where we get, for the countries of concern, most of those requests are from Chinese researchers. So we had to start that conversation with our members to say, how is your organization going to look at this risk? How do you want to manage it? So we started that conversation, and we kind of looked at how we were going to do that. So the first thing we do is the Vivli team, and I really do want to say a big thank you to Catherine Darcy, who's sitting in the corner back there, because she's the one who's looking at this in great detail to make sure that this is applied for every single request that comes through on the platform. So any requests from institutions that exceed those bulk thresholds, so anything, you remember we talked about the different limits, so anything that is over that 10,000 limit, they do not proceed. Or if it's an institution where we're already over that bulk threshold, so we're already at that kind of 10,000 has been shared in that year, they do not move forward. I have an example that will explain this, I think, a little clearer when we talk to that. We then talk to our members. So we ask the members to tell us how many US participants did you have in a given trial. So we then look at that and we calculate that total amount for that request for that institution. And we are tracking all of this as it goes through. We go through and verify that, and then we look at, can this move forward? Are we under that bulk threshold to allow us to do that? Having said that, all of our members have a different risk threshold. They make their own decisions about what they will and won't share and how that moves forward. So we tried to maintain that flexibility so that our members could make that decision. And really we're seeing kind of 4 different member approaches happen. The one we see quite a bit is what we call the case-by-case basis. So what's going on here, this is the most common. That means that one of our members will consider sharing if we're underneath the bulk threshold is not reached for that covered person or institution. Some have decided they just are not going to share with countries of concern. They've just, that given other activities they have going on, they cannot share. We do see some that will share studies that include non-US participants with countries of concern. Because if a study wasn't conducted in the US, it's not a problem, and so they can allow that sharing to occur. And then we also have some companies and members who are removing US participants from a study, and they will share the rest of the study, but not those US participants. So those are kind of the 4 different approaches that we have seen our members take as we work this through.
I ask just one clarification on
Can you ask with a mic for me, Steve? Just because the online team people can't hear. And I think Liz is coming right up. Go ahead.
Yeah, so on the 10K, is it a Vivli members threshold, or is it Vivli's threshold? Because member A might only have 5,000, and then member B has 5,000, and all of a sudden Vivli's at 10,000. So is it whose 10,000 is it that you're counting?
So it's the combined is the best way I would think about it. It's the combined total for an institution. So if it's an institution, say it's based in China. If it's an institution based in China, then we're looking at that total over 1 year if they cross over that 10,000 limit. So if I talk through this example, that might help.
Okay, so it's institution, not country.
It's institution, not country, and that is a key thing to remember. So let's say in this example, we have a university in a country of concern, and that's the kind of the key way to think about this. And there's 2 different investigators at a university. Many times we're dealing with many different investigators from the same university, so they don't know that one investigator, Dr. X, has put in a request to a data contributor, one of our members. They've requested that in April of this year after the ruling went into effect. And we've asked that member, how many US participants do you have? They have 5,000. Well, that one's fine. Request 1 from Dr. X can move through the whole process. Not a problem. But then you have another investigator from that same university come in, and they put in a request. They are going to, from a different Vivli member, so data contributor B, they put in that request in June, and we total up the amount, and they've got 5,001. Well, that puts that total for that institution at 10,001. That puts them over the limit. So as of July 1st, because of that end date, that's when that transaction would exceed the bulk threshold. So that is the point at which then request 2 could not move forward because we would start being over the limit. So if you can see, this is a rolling calendar over a year of any time someone's, if you get over that 10,000 number, that's when the request cannot move forward. And I can see some of you in the room kind of going, why did you all put this after lunch? This is a tough conversation. But this is really, this is the nuts and bolts of how we are having to implement something that is incredibly complicated. And so that's why we have a lot of checks in place to try to manage this, to try to think that through, to work this through for our members, to make sense of as this data comes in, comes out, and to try to, educate everyone so that they can make the decisions of how they would want to do that. I think it's also more complicated because this is ongoing. As David was talking about, we're seeing more changes, we're seeing more rulings coming out. So, we are continuing to need to watch this space as it kind of continues to evolve, as we do know it will. So those are some of the challenges that we have. So I can see, we are kind of moving on to questions. Would you please go ahead? I'll just move over to down on the panel. Thank you very much.
So apologies, but there's another lawyer in the house. But you said number of US participants. That doesn't specify citizenship. So is the assumption that if the clinical trial is occurring in the United States, that the participants are citizens or should be here legally or would fall under US citizen requirements as specified?
Yeah, so what I would generally tell clients, a lot of people like to go to the edge cases. So they're like, oh, well, we could have a US citizen that enrolls in Berlin, or to your point, we could have someone who's primarily a resident of Mexico who enrolls in the United States. But I think to implement the rule, you have to make some practical judgments and practical line drawing. And so most of the clients I work with are assuming that, if you're a clinical trial subject and you've been enrolled in the United States, that you're going to be a US person under the rule, and your data would be counted to the threshold. Conversely, most of my clients are taking a risk-based position that, if the site is in Germany, we're not going to expect that there's many US persons that are enrolled there. Of course, like the way the rule is, you're exactly right, a US person, US citizen, you're always going to be a US person under the rule wherever you go in the world, and so technically your data is protected. But when you think about it from, this is not strict liability, there's a scienter requirement, there's knowingness, like when you think of the facts and circumstances, unless somebody's showing you their US passport at the site in Berlin, which typically they wouldn't be doing, there's no way that you would know that they're a US person.
And just a quick follow-up question. Has there been any interest or desire of folks that you've been talking to start to track citizenship information? And I ask that not to be provocative, but I ask that with EHDS in mind.
With the European Health Data Space, no, I don't think this rule is causing people to track citizenship differently, because I think there would also run against, if you're doing a trial in Berlin, for example, then you would be subject to GDPR, and you'd have the idea of data minimization, and is it really necessary to know citizenship to run a study in Germany? I think that would run contrary to a lot of other principles. I also think, when we think about what DOJ is going to want to enforce against, I think they're going to be looking for things that are not like the edge case of a US person who lives in Germany type of scenario.
Thanks.
Okay, lots of questions.
Mine's just
Okay.
really quick, Julie. Just for that investigator B who was like the 5,001. So if it's a number of trials, do you work with them and say, well, look, maybe if you drop one trial, you're below the threshold, and then let them go?
So that's a great question. But we do not do that. It's a straight yes or no, because we certainly would not want to be seen to be doing anything to circumnavigate that ruling. So it's up to the, the researchers. We just share with them the ruling, and unfortunately, we cannot move this forward.
And there's a concept in the rule, if you read it, of prohibited evasion that talks about not engaging in activities that are attempting to circumvent the rule. And so you have to always keep that in mind as well when you're thinking about how to apply the rule.
So what if they reapplied and said, okay, now I'm only asking for like 4 trials instead of 5, then would you do it?
So there was a question here, do we tell them the reason? So we point to the ruling so that they can educate themselves and look at that ruling as well.
Next question.
Donna Snyder from WCG Clinical. So I have a scientific question related to this. Is each data point independent? And does it make a difference to remove, so if you have a study data set and you remove those individuals from that data set, how does that compromise the data overall?
I think that's a concern that have been raised of if you're removing some participants from a trial, what does that do to the power of that trial and kind of the representativeness of that trial? But I think, pragmatically, some are trying to just do the best they can with this decision and try to de-risk this as much as they can. David?
Hi, Julie. Thanks very much. That was a really interesting talk from both of you. There's always new regulations, aren't there? Can you comment on rules to universities based in the UK and Europe, what they are allowed to do with foreign nationals who are employees and PhD students?
I don't think either of us know the UK immigration laws enough to comment on that.
Sorry, I guess what I mean is, I don't, but let's say I had a Chinese PhD student who was working with me, and I wanted to do a Vivli project with them. Would I be able to do so?
Yeah, and I don't know what the UK's national security rules are, if they have similar policies. I think the one thing I would say is that if you have a grant from the NIH to do the research, so if you have a US grant, then you of course need to comply with all of the US grant terms and conditions, which, as we outlined, like with this new policy on biospecimens, would affect your research, But I don't know, the question you're asking is one that you should put to the in-house counsel at your institution in the UK about the limitations UK law might put on sharing data with countries of concern.
But sorry, my question was, would Vivli share the data with me under that situation, or would I need to undertake not to allow any Chinese students or staff to work on the data? Because that's what we're worried about, really, or not we personally, but that's
so you're thinking about in the Vivli scenario. So if you look at your contracts with Vivli, they've all been updated to prohibit onward transfers of the data. So it would be a responsibility of your institution that's signing the data use agreement to ensure that data are not shared with those countries of concern or covered persons.
And there is a very specific, in the Q&A, kind of explaining the rule that covers that specific case in terms of how that works, because that is a question we get asked quite a lot, and then we ask researchers to go back to their institution and say, you may want to look at this ruling in the Q&A. So there is quite good guidance in the Q&A from the Department of Justice on that issue.
So I've spent way too much time of 2025 dealing with this, but from the perspective of publications, so if someone wants to publish using Atlas data from Vivli, how is that being handled, or how's that being impacted? Because someone in a country of concern may have access to that journal.
But they would have access to the journal. They wouldn't have access to the data, correct? So
I guess if the publication has information about U.S. participants.
I can
you
try to help,
yeah,
not for Atlas specifically or Vivli, but questions about publications come up a lot.
Okay.
And I think what you have to think about is the transaction. Like if you're the one making the publication, like is there a covered person involved in the transaction? So if you're dealing with like a journal, in the PRC or a publishing company in a country of concern, then that could be a transaction with them. Like if you're publishing the data in the New England Journal, then somebody, yes, could read it. But that's not, you're not engaged in a transaction when you're dealing with the New England Journal. They're not a covered person. And so there's not a covered data transaction there. And then when they're selling their subscriptions, I think they would probably take the position that's not a covered data transaction because it's not data brokerage. But you're right, there's a lot of like interesting questions that come up with publication. We didn't talk about it because our limited time. There's also an exemption in the rule for data that at the time of the transaction are publicly available through open access repositories. And that can be helpful for some, data sets that are already in the public domain.
Even after April 8th?
Correct, if
Because-
it's open access repositories.
Yeah, I mean, it gets very complicated with the data sharing
Yes.
requirements of these publications in terms
Yes.
of what data informs the public, blah, blah, blah. So you talked about the NIH strict zero biospecimens
Yes.
to countries
Yeah.
of concern. What about data? Because
Yeah.
that is not data.
Yes, their policy that takes effect tomorrow is very focused on the physical biospecimen and not the data from which it is derived. They have policies.
Or that you can derive from it.
Or that
But-
you can derive from it,
But if we
correct.
sequenced all the DNA, then
It wouldn't
would be-
implicate the policy as it's written today. However, like there are other NIH policies that restrict access to NIH databases to people in countries of concern, and those took effect back in April, I think. So we're seeing like increasing numbers, increasing limitations, but you're right that the policy that came out that takes effect tomorrow is focused on the biospecimen. It also focuses on some cell lines,
Right.
and you have to look carefully at how that applies.
Yeah, but and you wouldn't have to worry about an NIH database. You could be doing it as an individual and not, yeah.
Okay, I think we'll turn to Ben for the last question. Thank you.
Thank you, Ben.
When we've talked about omics data in the past, I can't remember what the answer is to this. So if you think about like a tumor and you have a marker on that tumor, is that considered omics data? So would that reach the lower threshold, or is that only part of the 10,000 limit?
Yeah, so you have to look really specifically at those definitions and think about whether your marker fits into the definition of human genomic data, proteomic data, transcriptomic data, or there's one more, is metabolomic data. You have to look through those and match the exact definitions against the type of data that you have. That becomes super technical. So I always encourage everybody to go back to the definitions in the rule because they're very specific and there's a lot of examples.
Okay, thank you, everyone. Appreciate it.